Okay, everyone, we will get going. We've got about 35 people online and they're still trickling gently, but I think we should kick off. So my name's Georgia Mason. I'm director of the Campbell Centre for the Study of Animal Welfare, and welcome to the first research seminar of the semester. But as people living on the traditional lands of the indigenous peoples, it's an important week in other ways. It's not just the start of semester. So as you can see on the slide, it's Truth and Reconciliation Week, which started on Monday and goes on to Monday 30th. And there's a number of events I'd like to draw your attention to before introducing our first speaker in the topic today. So this week honors the 4,000 to 6,000 children who lost their lives in residential schools and the 150,000 plus survivors. And a first step to reconciliation is acknowledging the harms that these had. And obviously, as welfare scientists, we're incredibly well equipped to understand the lasting physical and mental health effects of chronic and repeated stress, especially early in infancy. And it's the legacies of this and the transgenerational effects that we see today still in many Indigenous communities. So if you're interested in making a difference and learning more, the National Truth and Reconciliation Centre has some online events today. So immediately after this talk, there's one about pretendians, which is people who fake being Indigenous. Tomorrow, there's one on the United Nations Declaration of the Rights of Indigenous People. And on Friday, there's a Canada-focused one on how we can address barriers to reconciliation. And if you're more interested in seeing what's happening on campus, it's just on somewhere else. Thank you. Great. On campus, there's a Campus Reads event where the university is encouraging everyone to read a novel. There's been a discussion that we've already missed. I don't know if anyone's read this, that authors from Brantford, and it's got rave reviews, and apparently it's darkly funny. I don't know how she managed that, but I'm definitely going to read this. Orange shirts to commemorate Orange Shirt Day on Monday are on sale at the bookstore, and £5 goes to the Woodland Institute, which is the site of what was the longest running residential school in Canada in Brantford. And then on Monday, which is Orange Shirt Day, walk in your orange shirts from the Art Gallery of Ontario to Branham Plaza, and there's a gathering on Branham Plaza at 10 a.m. with Indigenous speakers and musicians. And having Carolina here doesn't just kick off our research seminar series, but it also kicks off a series on animal law that will largely be on Zoom. It's been quite challenging to pull together, so that's why it's a bit of a seat of the pants production. But what we have coming up in December is Yvonne Nino from the World Veterinary Association talking about what good animal protection looks like, pulling out some examples from around the globe. Then in January, we have Camille Labchuk from Animal Justice, who's going to get her knives out and basically decimate the state of animal protection in Canada. And then we're going to pick ourselves up and look at a couple of solutions. Sophie Gaillard from the Montreal SPCA is going to ask whether declaring animals sentient in Canada would help better protect them. And then in March, we're just finalizing a speaker asking whether federalization of animal welfare legislation would also better protect animals in Canada. But first of all, we need to understand basic concepts and principles around animal law. I'm sure all of us in this room think protecting animals legally is important, but what does good look like? And what do we do when provinces differ in legislation and countries differ in legislation? And there's a load of sometimes complementary international and separate national policies. So Dr. Carolina Maciel is a lawyer by training. She comes from Brazil. She holds a master's degree in political sociology from the Federal University of Santa Catarina in Brazil. She then took a PhD in international law and policy from Wageningen University in the Netherlands, and then a master's degree in law from Harvard, which she's literally just finished. And some of her work on that is going to contribute to the second half of her talk. She's an international trade lawyer and a policy analyst specialist, and she's throughout her career been interested in providing a voice to the voiceless. Her experience around animals includes working with World Trade Organization agreements and working for the World Organization for Animal Health. And her past roles include advising the World Federation for Animals and being chair of the Americas Working Group of the International Coalition for Animal Welfare. So Dr. Maciel will present on dissecting animal law, identifying differences and key features. Thanks so much, Carolina. Thank you for the invitation.
Thank you very much for the invitation. I appreciate you and also Laura, all the help you have given me, and you for coming here, and you on the Zoom for joining us online. So thank you very much. So the idea on this kickoff event is really like dissecting animal law. I presume loads of you have some understanding or have some contact with the legislation, but perhaps having a little bit more clarification. What is the difference between cruelty and welfare from a legal perspective, not from a scientific perspective, but also what are important features of the legislation and how that domestic framework intersects with international trade. So to cover all of these, quite ambitious agenda, so I will try to keep track on the timing. I have divided the presentation in 3 parts. The first one to focus on terminology, the second one on features, and the third one on the interstate. So the terminology, I often see people talking with each other or even writing articles and using the words cruelty, rights, and welfare, and sometimes even conservation interchangeably. Like, for instance, oh, I fully support animal welfare because they have rights on it. Well, they are separate things to start with. So I'm just going to try and find the microphone. Yeah. So I would like to take this first part to separate, because animal law has different scopes. The first one will be cruelty. The second one will be sorry, I got distracted here. The first one will be the cruelty. The second one is about the protection, the conservation, and then the welfare, and finally the rights. And I wanted to start with bring a little bit of the historical context, because the laws actually are a social construct. It's a reflection of our time. It's a reflection of the debates we held as a citizen, as a thinker, as a scientist. So it's important to get a little bit of the context. I deleted most of my presentation because I didn't want to bother you with loads of historical facts, but I thought just a little bit. And then I will show you some examples of how this actually reflects on the legislation. And I brought examples from different countries. And I believe some of you will join me this afternoon for a different event. And I encourage each of you to bring some examples of Canada for each of these different types of animal law. So animal cruelty. Yeah, okay. Sorry about that. So the first one is animal cruelty, was the first one to come up. And when I say the first one, I'm talking about the 15th century, the 16th century, when society was building up civilization, was the notion of being civil with each other. Actually, even the United Nations legislation, they talk about this word to be civil. So we have to behave properly. And being violent against animals were actually a sign of not being a good human, not being dignified enough. So actually the very first legislation is about controlling human behavior, much more than controlling or protect the animal per se. And we will notice later that because the intent is to control the human behavior, not to be so violent, it's loaded with negative obligation. So not to do. You are not allowed to do that. You're not allowed. And it's also why anti-cruelty legislation is mostly framed within the criminal legislation. The second one we have, And some of you might be familiar with a book called Silent Spring. So from the 1964, we start understanding that nature is not only resources, not a resource for humans just to take and use as they wish. There is a connection, a equilibrium that must be kept. And here we started understanding about the need to adopt new legislation to protect wildlife, to protect the nature. So the legislation here is not, again, looking at the animal per se, and when it looks at the population. So environmental legislation, conservation looks at the population level, not at the individual level of the animals. It's about conserving. About similarly the same time, and actually the author of The Silent Spring, Rachel Carson, also provides the foreword of the book from Ruth Harrison that you might be familiar with, which is Animal Machine. So she also brings up that idea of everything connected. Human health is connected, animal health is connected, and that we need not only to hold back ourselves on cruelty, but also provide some care, some extra care. And then follow up of that, you might be familiar with the Brumble report that also puts the five freedom. But there is a very nice quote that it says, the existing legislation is focused on the cruelty. Now we need to shift focus. So here the shift of focus is about not only having the legislation negative obligation, but having positive obligation. So it's not about refrain some violent behavior. It's about encourage positive behavior in any interaction with the animals. But discussion continue. We still have different anxieties and expectation for how we live and how we want to be on the world. And we have the fourth possibility in animal law, which is the right. I will focus more on that, but it comes from the philosophical idea that there is too much emphasis on protecting one species over the other species. And once again, we need some balance here. And the rights, I will bring a little bit more at the front. What's the difference between law and rights? So keep with me now. And before I show some of the examples, I want to just highlight that law, it's a single unit, but with different tools, different frames. So constitutional law works very different from the criminal law, which works completely different with administrative law. These are not just labels. When even with the same obligation, do no harm, is written in a framework of a criminal law, and when it's written with the framework of an administrative law, lawyers will have at their disposal different tools to file for procedures. The judge will have different principles, different lengths to look at. So it's very, very important, whatever you are analyzing, interpreting the legislation, to identify what is the framework, what are the tools being used. So bringing out the examples that I promised before. So we don't need to pay attention and understand the whole legislation. I want to just highlight some of the words that reflect all this thinking that I summarize in 5 minutes. So you see here the anti-cruelty start as early as the 1641, which say no man shall exercise, so negative obligation. Usually that legislation is mostly restricted to some species. Most of the anti-cruel legislation do not apply across the border to all the species. They single out some species. Here a little bit more, and you see, again, I mentioned that mostly anti-cruelty is within a criminal framework. You notice here that I underline the word malicious intent, and here in the UK, you have untimely intent. This is a different benchmark on the mental state of the person taking that action. So this is also very important. It's also where the challenges sometimes and the frustration with some legislation lies, because sometimes the lawyer needs to prove the criminal intent, needs to prove. So that's why if the same situation is covered by the administrative legislation, for instance, that benchmark not necessarily needs to be met. I hear a little bit more other more recently example from the 1995. You see that the cruelty and abusive acts is once again linked with human dignity. So behaving in such way does not reflect what we as a society see as a good human dignity. Some other examples from Kenya now. And now passing to the next one, the next type, conservation. You notice here that once again, this type of legislation doesn't apply to all species. Usually it's more focused on wildlife, usually is focused on some of the actions like the hunting. And it uses a little bit of a mix between negative and positive obligation, but mostly negative, so prohibited some activities. Here a little bit more other examples, United States, and mostly of countries actually, they reflect the international agreements. So their legislation pretty much mimic the language that was agreed at the international level. We don't have, mostly because it's a criminal legislation, we don't have anything similar in terms of having a international agreement of cruelty, but we do have for conservation. So next, about the welfare. Here you see that now we start getting the animals. So it's not human dignity, it's not about the environment, biodiversity, it is about the needs of the individual animals. So you notice here that the language used on the legislation is different. It talks about ecological needs, the needs of animals. So that's where the emphasis of the legislation. But of course, we need to unpack what is the needs, and that comes most of you from the scientific, the natural science legislation to translate for us what it is, the needs of the animals. I hear a little bit more examples also from Colombia that uses the word sentient beings, compassionate handling. So you also see that it's not only about negative, the emphasis on welfare legislation is not on prohibiting, but in encourage good actions, in encouraging compassionate, encouraging feeding the animal, bringing water, fulfilling the needs. So it's a lot of positive obligations. And the last one about rights. So far, I have used the word law, and the law can mean the piece of legislation that I'm looking at, but it can also look at the field, so the group of legislation. In English, there is quite clear to see the difference when I use the word animal law and animal rights. But there is a lot of confusion, especially when we are talking, reading in Portuguese, my own mother tongue, or French, or Spanish, or perhaps even many other languages, where there is no difference on those two words. There is only one word. And there's so much confusion because people are talking about law, but addressing as it is right. So animal, and the word rights also has two meanings. One meaning is from the philosophy and ethical discussion, where we can discuss which rights they ought to have, ideally one should have. But we also have the words right from a legal perspective. And one person can only be entitled of a right if it's given by the legislation, so or with the court, but if it's legally recognized. So we need to also keep the difference between, so animal law, animal rights, and within the animal rights, there's two concept? Are we talking about more in a philosophical way, or we talk from a legal perspective? The second important difference when discussing this is the difference between legal person and biological person. I often see people freaking out when they talk about animal rights, and someone says that the animal rights is about giving animals legal personhood. They're freaking out. Oh my God, they're going to be exactly as us. They will have the same rights. But because they are looking at this from a biological person, so the word person in the legislation from a legal perspective is not linked or exclusive to human beings. A legal person can be, well, I don't have any paper here, but it can be a piece of paper. That is a legal person if in that piece of paper is one corporation is being incorporated. A ship is a legal person. So legal person is a category, is a status given by the legislation in order to ensure that that entity interest is being can reach the courts and the legal system. So do not freak out next time you hear the word legal personhood attached to animals, because legal personhood is a legal concept that is not exclusive for biological persons. It covers other entities. So with that, I want to give you some examples that are not entirely providing the rights, but are building the path towards that, in the sense that this legislation here are telling the following. So usually in the legislation, we have two categories. We have the subjects, who are those entitled with some rights, and we have the objects, who are where the rights apply to. So here they are saying, hey, they are not objects. Animals are not objects. Animals are not things. But it's still in the making, and each country have a different approach, whether or not to shift to one category, the first one, subjects of right, or to create a third one. So we are still experiencing that evolution of the legislation, this discussion about how we're going to actually provide animals with legal personhood. So also from other jurisdiction, Colombia. And you have here, I want to highlight before, remember that for the cruelty, I use a lot and I highlighted that the criminal framework was used mostly, for the welfare, mostly administrative. And for making this shift in legal personhood, the tool we need is the civil code. So we talk about civil legislation here. And also to highlight that legal personhood can come from the legislation, but also from court decisions. We have already some in Brazil and Argentina. So to wrap up this first part of the presentation, the first and the second. So we have different scopes and different frameworks. The terminology is very important, how we use. Law is not like a novel, is not like literature where we can say, oh, this is so beautiful. Yes, it's pretty. I agree. Can you see that I use like pretty and beautiful and agree with you? We cannot use the words interchange. We have to be very clear, Warrior. Are we discussing, are we applying, are we developing a legislation? Are we interpreting, are we implementing a legislation for the purpose of prevent cruelty, ensure conservation, promote the welfare, or recognize rights? And we have different tools to fulfill each of these objectives. Now, on the second part, I want to just highlight, it's very hard to compare and contrast legislation from different countries. And I thought it wouldn't be fair to make such a comparison out of the blue or in abstract. So the purpose of the second part is to bring or to highlight some key features that usually provide for a robust framework. So it's important that every legislation have a clear directive, a clear operative, and some substance. So what do I mean about directive? It has to be, you have no idea how many times we come across a piece of legislation and we are not really sure the scope of this legislation, or the purpose is quite of mix up, is blurred. So it's important to get it clear. What is the purpose and the scope? And it also helps if the legislation has some principles and definitions. The principles helps because it's a tool for interpreting the legislation. Sometimes we might have a clear rule, but if we have a principle, we can interpret and fill the gap through the principles. So here are just some examples. This legislation here from Peru, it brings the principle of comprehensive collaboration, the principle of harmonization with international law, precautionary principle. This other legislation from Brazil, all in terms of animal welfare, brings exactly the definition, what it understands about environmental enrichment in abnormal behavior. Another important feature of our legislation is to allocate authority with specific duties and powers. I have come across very beautiful legislation, extremely beautiful legislation at the local level. And at the end, okay, who is in force? Which government entity has the authority? It wasn't written there, and we couldn't figure out from. So it's a good intent, but it's a piece of legislation that's not gonna, let's say, survive. So it's also important if it also facilitates dialogue among stakeholders, and if it has a mechanism to monitor compliance and address non-compliance. Because again, sometimes it actually monitors compliance, but it doesn't say what to do when there is no compliance. And you can only do something, the state can only do something if it's provided in the legislation that it can take that measure. So it's important to have all those elements to make sure the legislation will bring that intent into actual operation. So here's some examples. This Thai legislation say the competent official shall have the power and duties as This other one from Malaysia have a board which will monitor, will provide education, lectures, book. And we have this other one from Peru also talking about, okay, what's the mechanism and what's the compliance? Finally, is the substance. So here is where you have to specify the relevant positive and negative obligation. When possible, establish some criteria, and when relevant, set deadlines for compliance. Because you might have different timeframes to accomplish different parts of the legislation. Here are some examples, one from Brazil about pig welfare that established the stock density with some numerical reference, later not so precise, but with indication of 25 degrees. Here, another example from Argentina. So to finalize this second part, the takeaway is that there is like a magical formula per se, but there is very important key elements that across the board will provide for a more robust legal framework. So in our, how many minutes I have left? About 15 minutes left. Okay, I want to talk a little bit about the different in the states. So Canada, Brazil, we saw here many different legislation. Each one use different terminology. Each one have different. But how do they actually talk with each other? What do we have at the international law? And it's also very brief, like 1 minute, I want to give you the historical background of the international trade legal framework. So we had the World War II, where countries were devastated in Europe, and we had a meeting called the Bretton Woods, which countries came together and signed the GATT. It was a general, it was an agreement that basically said, okay, let's come together and make sure that we are not going to use trade to retaliate. Another important principle is the principle of everyone will not discriminate on the basis of the nationality. Let's build a world where everyone is equal. But over time, let's say this principle of non-discrimination turned out to have some kind of difficulties when you think about when we do want to discriminate on the basis of the production methods. So not on the origin, which was the original idea, but it turns out that the principle of no discrimination also provided some constraints, let's say, on how do I discriminate one egg that comes from a production that uses battery cage and one egg that doesn't use that. So we came here, we have the GATT, we have different negotiations, and we have the Uruguay GATT, and finally 1995, so it's quite recent, in 1995, the World Trade Organization. And soon this new framework arrived, which the GATT, the original one in 1947, only applied for industrial goods. It's only in 1995 that starts to apply also to agricultural products. We had the civil society a little bit with a lot of anxiety of how that would impact the animals, because on that really big, there is over 30 different agreements under the WTO, the World Trade Organization, these agreements about how trade in goods and services cross the border and how countries can design their measures to permit these crossing borders. And because the word animal welfare, animal protection is not in any of these agreements, there was a lot of anxiety that, that's going to create conflict. That's going to be a hard bar. So we have so many reports from civil society, and we have articles say it's a growing pain because we don't know. We need to figure out whether or not this new legislation that do not talk about animal welfare will serve to restrict the ability of the governments to establish those new policies, or in fact will provide some support. So we have this completely big question mark. So in parallel, what the countries have started to do, because at the multilateral level, you have to get, you have to get the support of almost 160 plus countries. So we saw that the idea of animal welfare started to be included in bilateral agreements. The first one is quite some time ago, is in 2002. It was between the European Union and Chile, which wrote about the importance of the animal welfare in the cooperation between those European Union and Chile. Later, this agreement is still in valid nowadays. It's being now updated to bring even more comprehensive. Originally, it was restricted only to the slaughter and transport. Nowadays, the idea of collaborating on animal welfare is now covering the different stages of the animal production and different species. But we have other examples more recently. You have the EU, South Korea, we have the EU, Central America, and we see that it's each year or each new agreement, it's more elaborated. We have cooperation, technical assistance, equivalence being established between different standards. We have, most of you might be familiar or not, with the EU-Canada Free Trade Agreement, which also covers a little bit of animal welfare, could be a little bit more ambitious, I must say. We have the EU Mongolia, EU Vietnam, New Zealand, and look at that. In New Zealand, we don't, like the previous one, which was just one provision mentioning, we actually have one entire chapter dedicated to animal welfare, to enhance the cooperation, to recognize, to mutual recognition of the sentience of the animals, and to establish other channels of communication between between the governments. And that's quite an innovation, which is now is a different tariff. So when products cross the border, the government sets one tariff. And remember that I said about the discrimination. Usually you cannot discriminate, but now it's understood that you can discriminate by different tariffs on the base of the production. So it's quite innovative, and within bilateral agreements, you have more room than in multilateral agreements. So what we have nowadays is a wealth of bilateral regional agreements coming up and being each time a more fruitful avenue for incorporate those environmental, animal, and even human rights provisions. But in parallel of this, or we also say in international law studies that sometimes the bilateral agreements work as a laboratory for us to test ideas, to test approach, to test what governments accept or not. And then we kind of bring to the multilateral level where we have a bigger crowd. So there is nowadays a new reflection of, okay, the multilateral agreements under the WTO do not mention animal welfare per se, but they really are that detrimental to the animal, or have we exaggerated earlier? Was our previous understanding too negative, and perhaps they are not so harmful as we originally thought? So there's a new thinking coming through, new interpretation of the same agreements. Of the same agreements and of some important case, like landmark case. And in terms of the animal protection, the WTO has over 600 cases. What I mean about cases, the dispute between countries, when one country file a lawsuit against another country. So there's over 600. But we could say that specifically addressing animal protection is about 3 of them. So I want to bring here one example. It was one of the very first, you see here, DS58. So it was very at the beginning. One of the first cases was about a regulation established by the United States restricting the import of shrimps that did not use a certain method of capture, what is called the turtle excluder devices. So there was a complaint for some countries that felt their products were held at the border. There was a panel discussion, and the panel said, okay, it's indeed inconsistent with the international rules. But we had an appellate body. Perhaps it would be helpful to clarify. I keep forgetting that I'm not talking with a legal crowd. So the international, at the international level, within the WTO, when a country files a lawsuit with another country, the first stage is a discussion to see if they can come together in an agreement. So it's more like, let's talk through our problems. And if they don't reach a mutual satisfying result in this first phase called consultation, then it's called panel. So a group of experts is nominated and comes to analyze the case. And if one of the parts are not satisfied with the report issued by the panel, you can appeal, and then you go to the appellate body. So it's three phases procedure. So you see here that in the case of the US, when US was challenged for restricting the import of shrimps, the panel said, yeah, no, US legislation indeed violated international law because it discriminated. But the appellate body agreed that was inconsistent, but it actually provided for what is called a exception in the legislation about the conservation of exhaustible natural resource. So it's important to see here the difference, that the objective was to upheld by the WTO, but not the manner. So the manner in which the US implemented its legislation was unjustifiable because they provided a longer time frame for the domestic producers than they provided for importers. So remember the discrimination. They thought this was discriminate. So for foreign countries, you provide only 3 months, and here for your domestic markets, 3 years. But it's important to differentiate the decision here is not about the objective of the measure, it's about the manner in which the measure was implemented. Here it's just an example of the regional code where the appellate body said, we have not to decide that sovereign nations that are members of the WTO cannot adopt effective measures to protect endangered species, such as sea turtle. Clear they can and they should. So moving on to another example, a little bit more recently, and that was definitely a turning water in the legal discussion. And the European Union has adopted a legislation to protect the seals. And it therefore established that products derived from seals could not enter the European Union. And you might be familiar that Canada and Norway filed a complaint saying that was a unjustified discrimination. So there was a panel that concluded that EC had a legitimate technical requirement, but some aspects of that was a little inconsistent. Canada and Norway, once again, appeal, and also European Union, and they have the second part appellate body that concluded that, yes, EC was inconsistent with some of the rules, but they actually qualify for the provisional justification under the public morals. So again, what the WTO here decided was that the measure in itself, the idea to protect the seals, was a valid public moral, but the manner in which the European Union tried to implement its measure was found inconsistent because there wasn't clear distinction between the indigenous methods of the seal hunting. So here is just an example where we find the appellate body upholding the EU public morals. And what that shows us, it was what already most of us legal scholars was claiming. So this legislation, this case, was decided in 2014. So that's exactly what we have been telling people, that the original agreements from 1947 and 1995 did not have the word animal welfare or animal protection per se, but they not necessarily restrict the ability of governments to take measure. That was kind of like a lame excuse not to do so. So nowadays we have very clear understanding that the multilateral agreement permits, but of course, not every single measure. There is a difference between the manner in which the manner cannot be discriminatory. So with that, I finish here with 3 takeaways. So from the first part of my presentation, I hope you have taken with you that animal law has different purpose, and the purpose of the animal welfare should not be confused with the other one. So I know you all focus on the welfare and they complement each other, but do not confuse with the different purpose of the other animal protection law. From the second part, I hope you have taken with you the message that we have different regulatory frameworks which will suit each country legal framework, societal expectation, but it's important to, at least when you are interpreting the legislation, or if some of you will become advisors for government and will help to write legislation, try to keep in mind that three aspects. It has to have a very clear directive. It has to have some operative, like how do you operate this ideal? And third, what are the mechanisms we have to handle it? And thirdly, so the international trade agreements actually offers a basis for countries to collaborate, either bilateral at the regional level, but also at the multilateral level. So here are the sources and credits, and I thank you all for the attention.